Welcome to our company law class. So we are still discussing corporate finance, the aspect we call the shares. So just one or two things which are outstanding. We will tie the loose end and then we will switch over to the benches. Now, the last time we spent time discussing reduction of stated capital. We also discussed the general issue of resolutions, which required confirmation by the court. We look at all the various processes or procedures involved. So just an important aspect of shares we haven't discussed together. We're going to touch on that and then we move on to the benches quickly. So I'm talking about dividends. Dividends. So let's look at the law and then we will discuss it. We have already noted that when we started discussion of shares, that if you are a shareholder, the returns you get for being a shareholder or for having the shares in the company is that when the company has made profits, the profits may be shared. Of course, not all of it, because if you decide to share all the profits for the shareholders, it means you don't want the company to grow. So a portion of the profit may be declared as being available to be shared for shareholders. And when it is so declared, various shareholders will get a fraction of the profit declared as the dividends in proportion to the number of shares that they have. But it's still important that dividends are not done anyhow. And that is why we have very strict rules and which we need to pay attention to. That is why we are going to discuss what we are going to discuss now. So first and foremost, the company must have made profits before part of the profits will be declared as being available as dividends. That is part or portion of the profit made to be distributed to shareholders. But we do not want the company to create artificial dividends. And for that matter, if rules are not put in place to regulate how and when the company may come to conclusion that profits are available, and for that matter, the profits or part of it can be shared as dividends, you may end up letting the company eat into its operating capital. And that would also amount to violation of the capital maintenance doctrine. So legality of dividend payment is an aspect of capital maintenance doctrine, as it were. Now, in Ghana, the governing legal framework is Section 72 of the Companies Act 2019, Act 992. And Section 72 is to the effect, and I quote, subsection 1, except in a winding up, a company shall not pay a dividend to the shareholders of a company, or except in accordance with sections 78 to 72, make a return or distribution of any of the assets of the company to the shareholders of the company, unless the company has complied with the distribution test. So, to start with, the lawmaker is reminding the company, and for that matter, shareholders, that you can't just go about sharing or distributing profit or assets of the company in the name of paying yourself dividends. No. You must actually ensure that you have met a particular criteria. And if you look at section 72(1), you notice that the lawmaker has introduced a certain concept, and that concept is called distribution test. So the criteria for payment of lawful dividend is the distribution test. In other words, if we can make a determination as whether dividends the company has paid was done legally, was done lawfully, we must find out, did the company meet the distribution test? And the question is, what is a distribution test? I've told you that anytime you are reading any enactment or legislation, you come across words or phrases which are not ordinary words, you quickly jump to the interpretation section of that enactment. So for purposes of Act 992, the interpretation section is the first schedule. Now, if you go to the first schedule, we have the interpretation or definition of words. So you look up distribution test. And according to the interpretation section, this is the meaning of distribution test, and I quote, distribution test includes circumstances where A, a company is able to pay its debts as a fall due, and B, the amount or value of any payment, return or distribution made by the company does not exceed its retained earnings immediately before the making of the payment, return or distribution. Yeah, so that is pretty straightforward. The distribution test, if you like, is a two-pronged. First, is the company in position to be able to pay its debts and liabilities if it decided to pay dividends? Now, where that is answered in the affirmative, that is where the answer is yes, we haven't finished. You look at the second aspect of it. Now, the dividends, or which is going to be paid, is it such that it is less than the retained earnings of the company? If the money going to be paid is less than the retained earnings before the payment is made, then it is safe for the company to pay dividends. So the takeaway is that a company can make lawful payment of dividend where the company has satisfied or complied with the distribution test in terms of section 72, subsection 1. And distribution test, according to the first schedule of Act 992, simply means that the company has the ability to pay its debts and liabilities. And two, the payment of dividends going to be made, the amount going to be paid, should be less than the retained earnings of the company. So let's keep that in mind. And don't forget that we've already discussed the retained earnings under section 71 at our last meeting. And among other things, we said that the retained earnings basically refers to the monies which the company has made in terms of the assets. And we say like the assets, the shares that the company has given out, the company gets money, the consideration which the company has actually received. We are not talking about the unpaid one. We are talking about like the actual paid one. Now, if you adjust the monies the company has received from the debts that the company is owing, the balance would, generally speaking, be what we call like the reserves. So the income or the income capital, if you like to put it in a very practical way, which the company has made from the shares that it has actually issued, and taking away the various liabilities of the company from that, what is left will be what we call like the reserves of the company. And we are saying that the reserves of the company also constitute the retained earnings, provided we take out the unrealized appreciation in the value of an asset. You know, when the company has an asset, it gains in value, right? It appreciates. But that, in a sense, forms part of, if you like, the assets of the company. But when we are trying to determine, mathematically or in accounting terms, what the retained earnings are, we need to knock out the unrealized appreciation in the value of the assets. And then we should also take out balance standing to the credit of the shared use account. If you remember, the shared use account is the account which is set up where shares are issued, money needs to be raised in order to finance redemption of redeemable preference share and so on. So that is like the shared use account. So when you have taken monies which are standing to the credit balance of the shared use account from the reserves, then what we have is what we call like the retained earnings. So the point being made is that part of the distribution test means that the amount of money the company is going to pay as dividend should not be equal to the retained earnings, should be at least somewhat less than the retained earnings. So that is a general principle which governs legality of payment of dividend. Now, where that distribution test is not met, and then the company goes ahead to distribute dividends, there are consequences. And what are those consequences? Section 72, subsection 2 says that where the company has made unlawful payment of dividends, then A, every director of the company who is in default, I mean, that is who superintended over the company when the company was actually paying dividends without meeting the distribution test, will have to actually pay back the total amount of money which was paid as dividends or which was returned to shareholders, as it were. And interest will have to be paid on it using the 91-day government treasury bill. So if, for example, the 91-day government treasury bill is, let's say, 27%, and let's suppose that the total amount of money distributed to shareholders as dividends is, let's say, about 1 million Ghana cedis. What it means is that the directors involved will have to pay the 1 million Ghana cedis, and in addition to interest calculated at the yearly interest rate of 91-day government treasury bill. So let's keep that in mind. And another consequence is also that where if you look at the B, unless within 12 months after the date of payment, return, or distribution, the total amount of money with interest on the payment, return, or distribution is restored to the company by the directors in accordance with paragraph A, every shareholder is liable to restore to the company the amount of money received by the shareholder in contravention of this section. So if you look at it, we have what they call the levels of responsibility or liability. First, directors will have to bear the initial liability or responsibility for superintending over the company when the company made illegal payment or dividends. So the directors have to return the total money paid. And as we noted, interest will have to be paid as it were. And if the restoration is not done by the directors within 12 months, then the shareholders who receive the money, each of them will have to pay the money received back to the company. And of course, they too will have to pay interest on it. Now, the C makes a variation to bring some fairness into the blame game. So if the directors of the company make a resolution to the company in accordance with paragraph A, as we have seen, that they pay and also pay the 91-day government treasury bill rate as interest, they shall have a right to be indemnified by a shareholder who has received an amount of money, knowing that it contravenes this section to the extent of the amount received by the shareholder with interest on that account at the yearly interest rate of 91-day government treasury bill. Now, where the directors, having presided over the company, for the company to pay dividends illegally, they comply with the consequence of the law by restoring the money paid illegally back to the company together with the interest rate using the 91-day government treasury bill. Now, the law entitles the directors concerned, as it were, to exercise the right of indemnity. In other words, to also go to the shareholders, because the shareholders are those who benefited from the dividends. Dividends are declared to shareholders. So the money has actually landed their pocket. So now that the directors have restored the money to the company, the directors have the right to pursue the shareholders for them to pay back the money to the directors who did the restoration. And the directors are also entitled to have interest paid by the shareholders concerned using the 91-day government treasury bill, as it were. Of course, if that were not the case, it will amount to unjust enrichment and also gross injustice to the directors. Mind you, they are directors, all right. They presided over the company when the company passed resolution. Because when it comes to dividends, we pass ordinary resolution. Ordinary resolution is passed by shareholders. All that directors will have to do is to make a recommendation that we think that having made profit of 5 million, 3 million can be distributed as dividends. And the shareholders will give their blessing by voting in the form of ordinary resolution. And then the payment is made. So the shareholders have benefited. Now, if it turns out that the distribution test, as we have explained, has not been met, and for that matter, the dividend so paid was illegal, and the directors have to restore the monies distributed as dividends, in this case, the 3 million Ghana cedis to the company, and in addition to the accrued interest on same, using the 91-day government treasury bill rate. Then the shareholders who actually receive the money should not be permitted to hold on to the money they receive. It will have to be paid to the directors who have actually refunded it to the company already. So that is the point being made. But the good thing is that if you do not want trouble, okay, if you do not want trouble, maybe as the accounts will say, it's because of trouble. That is why everyone has got a name. If you don't want a trouble, you're a shareholder in a company, you're a director or an officer or creditor of a company, and you become aware that the company is about to distribute dividends, about to return some of its assets to the company. And the company has actually not satisfied what the law has prescribed as a distribution test. And for that matter, the dividends or the return of assets they are going to make is going to be an illegal one. You do not have to wait for that to occur. You can go to court, or you can bring the registrar of companies' attention to it. Then the registrar can also go to court for the court to grant an injunction restraining the company from paying a dividend or from making the return on distribution when the company has not actually met the distribution test, or where the payment has already been made. The company has already paid dividends illegally. You can also go to court and ask the court to order the defaulting directors or shareholders, as it were, to make restoration of the illegal dividends paid back to the company. And of course, where you make such an application, as we have discussed before, the application will have to be made in a representative capacity. The application will have to be made in a representative capacity, and the application being made in representative capacity simply means that you are not actually you are not going to benefit from the successful outcome of the application alone, because what you are complaining of, or that which is taking you to court, other people have also got a similar complaint. And for that matter, when you are going to court, you are going in the name of all the people who are affected. And that is why you have to go in representative capacity. Now, when it comes to public companies, as far as payment of dividends are concerned, we have a bit of a modification of the rules, especially if we look at section 320, right? Let's go to section 320 and come. Good. If part, the part B applies to, public companies, not private companies, remember? So if you look at, and that is why the sessional subheading is limitation on liability of members in public company to restore illegal dividends. So section 320 is to the effect, and I quote, where a public company pays a dividend in contravention of subsection 1 of section 72, a member of the company, don't forget, section 72(1) is simply talking about the fact that the company cannot pay dividends unless it has complied or satisfied the distribution test. And the distribution test, we've been explaining basically mean two things. One, the company must have ability to pay assets and liabilities. Two, the amount of money going to be distributed as dividends or return of assets should be less than the retained earnings of the company. Now, where the company has not satisfied this requirement, we say that it has not met the distribution test. Then, in the case of a public company, Section 320 is saying that a member of the company is not liable to restore to the company the amount received by the member in respect of the dividend if the member proves that at the time when the member received the money, the member did not know that the payment contravened the subsection that we've talked about. In other words, of course, if you take a public company, don't forget that by definition, a public company, usually the membership is more than what, 50 and all that. I mean, there are a lot. You take even, let's take those of us who are shareholders of MTN or maybe some other banks. You will notice that we are so many, even when meetings are called, you may not even attend the meeting. There are some companies that maybe I'm a shareholder in for a very long time. I never attended any of their general meetings. You go for the annual general meeting, then the ordinary resolution is passed for payment of what? Of dividends. Now, I'm not there. I don't know anything about it. Or that I get alert that dividends have been paid. So take your dividend warrant and then go and they'll pay the money to you. Then so I follow it up. It's paid to me. Now, I did not know that when the company was resolving to pay the dividends, the company had not actually met the distribution test. And for that matter, the dividend was illegal. So where I can prove that I was not aware, then Section 320 is saying that being a public company, a shareholder will not be held liable to restore amount of money paid to him as illegal dividend if he can prove that, yes, at the time of receiving it, he was honestly not aware that what he was receiving was what was illegal dividend, as it were. And I hope you appreciate why the law is discriminating against private companies. Obviously, private companies, the membership very relatively small, and they may just even 2 members or 3 or 4 members and so on. So it will not happen that the company is going to decide to distribute or pay dividends, and you will not know the true circumstances in terms of whether the company has met the distribution test or has not met it, and so on. So that is why Section 320 is in relation to only public companies and not private companies. So let's keep that in mind. Now, there's also this concept of what we call the interim dividends in a public company. And let's touch on that with respect to Section 321 before we go back to Section 72 to continue our discussion. Interim dividends, according to Section 321, goes like this. The directors of a public company with shares may, unless the registered constitution of the company or otherwise provides, pay to the members of the company interim dividends on account of dividends to be declared by the company in accordance with Section 76. So, as the term suggests, interim, that is to say that dividends that we are paying to shareholders ahead of formal or official declaration of dividends. Before dividends are formally declared, processes and procedures will have to be exhausted and all that. However, if the constitution of the company is not expressly forbidding payment of interim dividends, then the law, in terms of Section 321, is saying that a public company can go ahead and make interim dividend payment to shareholders before formal declaration of dividends. And in fact, if I take MTN, when they did this in the IPO and all that, I got a little bit of their shares. Of course, I didn't know it was going to be a good thing as you have raised more money to buy more, but I think I got a little bit, something, not much, less than 10,000 Ghana cedis at the time. And recently, when you get an alert and you say that the interim dividend has been paid, then a meeting is held. The AGM is held. After that, after some time, they will tell you that the final dividend, that is no longer interim, confirmed dividend is paid. So that is what is contemplated by section 321. So for purposes of subsection 1, a dividend shall not be paid in contravention of section 72. And you know section 72 already. Yes, the law allows you to pay interim dividend, but still, you have to make sure that you meet the distribution test. So that is very important. And then where the distribution test is not met, and you go ahead to make interim payment or dividend, there are consequences. And the consequences prescribed for payment of illegal dividends under section 72 would apply mutatis mutandis, or with necessary modification as it were. So let's go back to section 72. Control F. So legality of dividends. Yeah, okay, so we just finished discussion on 72, and we have to make a detour to section 320 because of public companies. Now let's look at the unclaimed dividends accounts, where dividends have been declared, and shareholders, instead of going to claim their dividends, they don't go and claim it. How should that money be managed? So section 73 is to the effect that, 1, where any dividend declared by a company cannot be paid by reason of the dividends being unclaimed by the member entitled to the dividend and remains unclaimed for a period of 3 months, the company shall forthwith open an interest-bearing unclaimed dividend account, and B, credit to that account the total amount of unclaimed dividend of its shareholders, unless that account has already been opened. So dividends, which has been declared, is money meant for the shareholder. For a number of reasons, a shareholder may not come forward to claim his dividends or take his dividends. And the reasons may include that either the shareholder does not have time, the shareholder is diseased, the shareholder is not available, has traveled, or whatever. It can be any reason. But the bottom line is that dividend have been declared, and then the shareholder has not come to take his dividend. So what happens to such a situation? Now, if you look at the old law, okay, if we look at the old law, if I say the old law, that is a repealed Companies Act 1963 at 179. The provision which govern dividends was section 73, declaration of dividend. And the law was quite silent on a number of things, especially what should happen to dividends which has been declared, and those who are supposed to take the dividends, they don't come forward and take it. And that is why Section 73 has made provision that, yes, the company should open an account and deposit or credit the dividend meant for the shareholders in that account. And of course, that account should yield interest as it were. And when, of course, so when dividends are declared, there's what they call a 3 months moratorium, meaning that the shareholders have up to 3 months to go and demand their dividends. After 3 months, if the money has not been claimed, the company is supposed to open this account, unclaimed dividend account, and have the money deposited in it. Now, after doing this, if within like 12 months, so let's say that the 9 months, okay, 9 months, no, say like a further period of 12 months, okay. So after opening the account, 12 months elapses, no claim has been made. The shareholders who are supposed to take the dividends have not come forward and claim it. Then Section 73(2) is saying that the company shall pay to the registrar of companies the total amount of the unclaimed dividend plus interest accrued on the amount. And this is where I have serious disagreement with. And I think that, of course, the lawmaker is just trying to cheat the company, as it were, because where profit is made, dividends declared, yes, the dividend is for the shareholder. But here's the case: the shareholder has not come forward to claim the money. So the law directed that the company should open an account, deposit it in it, and then let it yield interest. Now, after opening the account, you are supposed to wait for another 12 months. 12 months from opening the account and depositing that or lodging the dividend in it. If the shareholder does not come forward and claim it, then the new law, that is Act 992, is saying that the company should not keep the unclaimed dividend, which has yielded a bit of interest, in its funds. It should hand it over to the registrar of companies together with the interest. And I think that the lawmaker, or for that matter, the state, is just abusing its authority to regulate companies. And why should, if the money is not claimed, it will form part of the money available to the company, and then it will augment, if you like, the operating capital of the company. So why should it be handed over to the registrar of companies? So if you look at subsection 3, that the registrar, that's the registrar of companies, shall pay into the account. If you look at the subsection 4, and subsection 4 should have actually come before subsection 3. There's a drafting infelicity or disorder. But subsection 4 says that the registrar shall, with the approval of the board, that is the board, the board of directors, which is supposed to regulate the registrar of companies, open an interest-bearing account for the safekeeping of monies received from any company. So under the new regime, under Act 992, the registrar of companies is supposed to have a general account for the sole purpose of safekeeping of unclaimed dividends plus interest accrued thereon from various companies in the country. Yeah, so where the money is paid to the company, then under subsection 3, the registrar shall actually lodge the unclaimed dividends received from the company into this special account. And mind you, this account is outside the company. This account is under the control of the Registrar of Companies. So under the new law, it's actually sweet. If you are the Registrar of Companies, you have access to a lot of money. Subsection 5, the registrar is responsible for the monies lodged and disbursed from the interest-bearing accounts, as I told you. All the various companies in the country where dividends are declared, people don't come for it within, let's say, 3 months plus 12 months, about 15 months. The monies are supposed to come to the Register of Companies and deposited in this account, and this account is actually controlled by the registrar. Subsection 6, the company shall, on the date of payment under subsection 2, notify the respective shareholder or the estate of the shareholder at the last address known to the company of the payment made in respect of the dividend. So look at it. Where dividends is on claim, as we have seen, and you deposit it in the account, the company is obligated to inform the shareholder, because the company is supposed to have a register of shareholders or members. And in the register of members, people's addresses or contact will be there. So even if the shareholder or the member is dead, his estate, his personal representative can be contacted. So they're supposed to be notified that, yes, dividends have been declared, you haven't claimed it. And this is where we are keeping the money. Subsection 7, the shareholder or estate of the shareholder shall, on providing satisfactory evidence, be entitled to make a claim for dividend and any accrued interest during the period that A, the company had possession of the dividend under subsection 1, and B, registrar had possession of dividend under subsection 3. Yeah, so once the shareholder or the personal representative of the shareholder, in the case of a deceased shareholder, become aware that, yes, this shareholder or that shareholder was supposed to have claimed this dividend, but due to certain reasons, remained unclaimed. Now, we have the evidence that, yes, he is so entitled. So please pay the dividends to us. Where the appropriate evidence is actually adduced to the satisfaction of the company and so on, or the registrar, that is where the dividend has moved from the company to the registrar in terms of what we saw after the 12 months, then the money will be paid to the shareholder or the estate after the necessary proof. So that is the point. And another new development under the current Act 992 is that in terms of Section 73, subsection 8, the registrar shall publish annually in the company's bulletin and in daily newspaper of national circulation details of shareholders whose dividends have been transferred to the registrar for safekeeping. Now, this law has been in force since 2019, and we are in 2024. So roughly 5 years. I stand to be corrected, but well, probably because I don't see daily graphic every day. I'm yet to see whether the Register of Companies has actually made such publication. That is, publishing details of shareholders whose dividends have been transferred to the registrar for safekeeping. If anybody has come across one, he or she can share the information with us. Or is it the case that despite the regime established under Section 73 for handing over unclaimed dividends to the Register of Companies for safekeeping, that provision has not been triggered, has not been activated? Is that the case? Or it has been activated and the Registrar of Companies has actually decided to remain silent by not telling the public regarding those whose dividends have been transferred to it? Because the purpose of the publication is that if people get to know, they can then follow up and go and demand payment of their dividends by the registrar, as it were. Section 74. How is the unclaimed dividends account managed? Section 74 is to the effect that the register of companies shall keep unclaimed dividends lodged in account, as we have discussed, for 7 years. For 7 years. 7 years is quite a period, isn't it? Look at it. And I think the lawmaker, I don't know whether, of course, we don't have maybe a front, but I think that the AGI, Association of Ghana, Industries, and probably Employers Association, and others, they should have been more concerned about section 73 and 74, because look at it. The company can hold on to the unclaimed dividend for only 3 months. Okay, let's say for 15 months, because 3 months it will hold on to it, and then 12 months you're supposed to keep it in account. So let's say for 15 months. Now, after 15 months, the company is supposed to hand the unclaimed dividends to the register of companies. And the register of companies is supposed to keep it for how long? For 7 years. 7 years. And so mind you, the register of companies is going to invest this. Even if you invested this in just a 91-day government treasury bill, you can imagine the amount of money that will get over 7 years. So why is it that the company was not allowed to keep the unclaimed dividend? So those of you who are doing dissertation, right? I've raised a lot of issues which give a lot of food for thinking, and we can build projects around it. So why is it that the company was not allowed by the lawmaker to hold on to the unclaimed dividend for, let's say, 3 years? Just to be modest, 3 years before handing it over to the register of companies, so that probably the register of companies also hold on to for 4 years before any further direction, as we have under section 74.2 or follow. So 74.2, the registrar shall, on the expiration of the 7-year period referred to in subsection 1A, transfer to the consolidated fund 50% of the total amount of money lodged in the interest-bearing account under subsection 4 of section 73, as we'll be discussing, and B, donate or apply 50% of the total amount of money lodged in the interest-bearing account under section 73.4 for the purpose of investor education, research, entrepreneurial development, and advancement in company law. I mean, this is a brave new world, new development in Kojokrom, isn't it? This is completely new, actually. So, after the company has handed the unclaimed dividends to the register of companies, and the register of companies having deposited this in the special purpose account for 7 years, if it still remains unclaimed, because the law requires that every year, the registrar is supposed to make at least one publication in terms of shareholders whose dividends are being kept by the registrar. So after doing this for 7 years, if nobody still comes forward to claim, then section 74 is saying that the monies being kept by the registrar should be split into 2. That is 50%. So half of it should go to the consolidated fund. And the consolidated fund is a constitutional creation under the 1992 Constitution. One of the most important and permanent account of fund of Ghana, and it's out of which a lot of national expenditure is actually met from. So half of that money is supposed to be put into the consolidated fund, and then the other half is supposed to be used by the registrar of companies for the following purposes: investor education, for promoting research, entrepreneurial development, advancement in company law. So that is why I said that under the new Companies Act, the Register of Companies is now going to get a lot of money. They can do a lot of things. So if you are thinking of a career, if I were a student like you, and I'm thinking of a career, maybe looking at this law, I may be tempted to explore career and probably one day become the Registrar of Companies or a senior officer there. 74.3, where a company on the commencement of this act has in possession of the company unclaimed dividends, the company shall immediately transfer the total amount of the dividends to the registrar to be applied in accordance with subsections 1 and 2. Yeah, so this is supposed to be what we call like a transitional arrangement. And mind you, this law came into force just 2019. So we are looking at unclaimed dividend as at the time that the money came into, the new law came into force. Then the 74.3 saying that immediately, if you have unclaimed dividends, you must process it as we have been discussing without wasting time. Now, just before we draw the curtain down on dividend discussion, let us remind ourselves that it is a strict legal principle that companies limited by guarantees in Ghana are prohibited from payment of dividends. So if you look at section 75.1, there's a complete prohibition. A company limited by a guarantee shall not at any time pay a dividend or make distribution or return of the assets of the company to members of the company. So here, there's nothing like whether section 72.1, the distribution test has been met. No, it's not about that. You are forbidden from paying dividends because you are company limited by guarantee. And where you flout that, then there are consequences. So section 75.2 says that where a company limited by guarantee, for example, pays a dividend, then every member to whom a dividend was paid shall restore the amount of money received to the company with interest at the yearly interest rate of 91-day government treasury bill. And every officer, that is every director who was cognizant of the fact that it's a company limited by guarantee, they are not supposed to pay dividend, and they protect over it in paying dividends, they too shall also pay administrative penalty of 500 penalty units. So here we have like a double-edged, right, rule. Members in the company limited by guarantee who collected dividend when the company is not supposed to pay dividend, they will be compelled to pay the money back to the company together with interest accruing on it using the 91-day government treasury bill rate. And then secondly, the officers, directors, and so on, who superintended the company limited by guarantee in paying dividends would be punished by being fined. And the fine here is not the normal fine, which is meted out by the court, but this is what we call the administrative penalty unit. So 500 administrative penalty units. This will be meted out even by the registrar of companies, as it were. Now, how is dividend declared? Section 76 stipulates that subject to section 72 and 75, in the case of private company, its registered constitution, where applicable, a company may, by ordinary resolution, declare dividends in respect of a year or any other specified period, but the dividend shall not exceed the amount recommended by the directors. So 70 says one, the takeaway is that first, if the company has not made special rules in its constitution regarding how payments should be made, then the general rule or the default rule is that dividend is declared by passage of ordinary resolution. Ordinary resolution, that is, the general meeting is held, then the simple majority approving it, decision is made. That's ordinary resolution. Two, when dividends are to be declared, they are declared in respect of a particular year or a defined period. Dividend is always referable to a particular time frame, either a particular year or biannual or whatever. So that is the point. But dividend is never if you like, at large. No, it's not generalized. But there's a third rule. The company cannot resolve to declare dividend greater than the amount recommended by directors. And let's keep this in mind. Directors of the company never resolve to pay dividends. The directors, they know the true financial health of the company. And on that basis, they will make recommendation to the company that, aware of the legal requirement that the company should meet the distribution tests, the company must have the ability to pay debts and liabilities. The company should be able to, the amount is going to pay out as dividend should be less than its retained earnings. Now, when the directors have taken all these things into account, then they say that, okay, the company has made a profit of 1 million Ghana cedis. We recommend that the company, for that matter, shareholders, may resolve to share, let's say, 500,000 cedis as dividends, or 300,000 or 200,000 out of the 1 million profit made as dividends. So let's keep that in mind. The members, and then here we have important checks and balances, right? And that is why I have told students many years and at different times and places that there's a close relationship between constitutional law and company law. So you have like some sort of like checks and balances here. The power to declare dividends lies with the shareholders. However, the shareholders cannot exercise the power in vacuum. They should exercise the power within the context of recommendation made by what? Directors. So from 0 to the maximum amount of money recommended by directors, they can decide to pitch the dividends within any of such range, but they can never go beyond the amount which the directors have recommended. Of course, with respect to public companies, we already discussed section 321, the additional rules which govern payment of dividends, and also the interim payment of dividends and all that. 70 says 3, a dividend shall be paid within 60 days after the resolution of the shareholders confirming payments, or after dividends have become payable. Yeah, so when resolution is paid for payment of dividends, if you're a shareholder and if you need money to spend, you have to start watching from the day that was passed up to the 60th day. You are entitled to get your money paid within that period. But in practice, where before the company will even hold the meeting and all that. They have done all the necessary paperwork. So as soon as the resolution is passed, within a day or two, shareholders can start assessing their money. 4, where a dividend is to be paid in accordance with subsection 3, the shareholder shall be notified of the amount of dividend recommended by directors for payment. Okay, so let us keep that in mind, because as we said, shareholders cannot actually resolve to pay more than the amount recommended by the directors. And that is why they should be informed of how much directors are recommended should be paid as dividends, as it were. 76.5, a registered constitution of a company may prescribe most for the payment of dividend without reference to the resolution of shareholders. Yeah, so this is consistent with what we saw in section 76.1, that subject to registered constitution. So if the constitution of the company has got its own special rules regarding payment of dividends, and for example, it says that dividends may be prescribed under certain circumstances, and shareholders do not have to pass resolution, then so be it. Because the shareholders themselves have actually approved the registered constitution before it was registered. So they have already agreed on how dividends should be declared, and that will be like the governing approach. We've discussed capitalization issued before, but just in case you have forgotten, we will just summarize it. Capitalization issues and non-cash dividends. If you remember, when we were discussing payment for shares, okay, we did make the point that shares are issued in return for valuable consideration. The only exception is where you have capitalization issued, also known as a bonus issue. And then we jump to section 77 to discuss that. So 77.1, when a company resolves to transfer a sum of money from reserves to stated capital, pursuant to paragraph C1 of 68, the company, on recommendation of the directors, may, by the same or subsequent special resolution, resolve that unissued shares in the company be issued and credited as fully paid to the members who will have been entitled to receive that sum of money had it been paid lawfully, lawfully distributed by way of dividend, and in the same proportion, so that the sum of money so transferred to stated capital shall be deemed to be paid otherwise than in cash on the shares. I mean, 77.1 simply means that the company, having made enough surplus or profits, and instead of saying that, okay, this is the profit we are going to distribute as dividends, for some reason, the company may probably need more money, and the company may not want to dilute shareholding structure in the company by allowing outsiders to come and take some of the initial shares. So the company can pass a special resolution, in respect of which advance notice will be given, and then 75% should approve it when it is put to vote. And the company will say that instead of we distributing this money as dividends, let us plow it into the company. And in exchange for that, we are going to give every shareholder the number of shares equivalent to the amount of dividend which will have been paid to you if the company had actually decided to share the profit as what? As dividend. So that is what we mean by the capitalization issue. So when the shares are equivalent to the amount of shares which have been paid to you, actually issued to you, in the company records, the company is going to make an entry that you are fully paid for those shares because you have money which ought to have been paid to you as dividends, but it's not being paid to you. And in lieu of that, you are being given more of the unissued shares of the company. So let's keep that in mind. And that is why 77(2) says that where shares are issued, under such circumstances, we call it capitalization issue. Or in some other literature, they call it the bonus word issue, as it were. We have discussed this before, and for that matter, I'm going to draw the curtain down here, unless you have questions, and then I will deal with the questions. So if you want to speak, just raise up your hand.